interim leader, John Steenhuisen, joins us via Skype line. John, it's great having you with us. Do you feel vindicated by yesterday's ruling?
Well, not vindicated because it wasn't our court case, but nonetheless, I think it's a very good portent for the number of court cases that we have that are pending before various courts in South Africa. We've got 3 cases before the High Court, and we've got a case before the Constitutional Court that we'll be arguing. I think this has been a major setback for government, and hopefully it's going to force them to reconsider some of the more irrational, unreasonable and petty regulations that have been put in place during this time.
John, it's interesting that you say consider some of the more irrational regulations that have been put in place over time, and that's also what the conclusion of this judgment says, you know, that we must be mindful of the fact that the COVID-19 danger still exists in South Africa, and despite several shortcomings in the regulations, there still needs to be some structure in place.
Absolutely, I couldn't agree more, and we've been very clear on the beginning that we would support any regulations or restrictions that were based on an epidemiological level or made sense. But frankly, the majority of these regulations, from what clothes you can buy, how you must wear them, restrictions on what you can drink and what you can smoke, restrictions on when you can exercise and when you can't, and the movement of citizens in a free democracy under a military curfew are irrational, unreasonable and not required. And those are the regulations we've taken to court. We fully accept that COVID is going to be with us for the next 18 to 24 months. Of course, we've got to have means to manage the virus. But you do this by building a compact with citizens where you treat them as adults and you treat them as democratic citizens, not as subjects. Unfortunately, many of these regulations have done quite the opposite and have led to a resistance from the population because of the pettiness and unreasonableness of them.
Yeah, and part of the action taken by the DA was to challenge the constitutionality of the Disaster Management Act. The court ruling yesterday coming out to say that it found that it was irrational, which raises the question, what next then for the party insofar as that issue is concerned?
Yeah. Well, we're going to court, to the Constitutional Court, to have the Disaster Management Act declared unconstitutional. And our main thrust of attack there is the fact that there's no oversight for the executive during this time. Even under a state of emergency, the president's got to come back every 21 days to Parliament to seek a renewal of this. If we, to keep the Disaster Management Act as it is currently, we could stay potentially in a level 5 hard lockdown for 4 weeks, 4 months or 4 years. All the while the country's elected representatives have no say, and as we've seen, the executive have taken over the lawmaking function of Parliament. We've seen tobacco laws changed at a whim by Nkosazana Dlamini-Zuma. We've seen draconian regulations being put in place with absolutely no input from the elected legislators in the country.
John, just looking at the conclusions again from what the High Court had to say yesterday, in fact, the first point there in the section under conclusions is that the Disaster Management Act was found to be rational. The Minister's declaration of the Act found to be rational. You're now taking this very issue, the Disaster Management Act itself, to the Constitutional Court. Any response from the Constitutional Court, or whether you will be given a hearing on that issue?
Yeah, so I think we must just be very clear that it is the lack of oversight in the Disaster Management Act that we are hoping to have declared unconstitutional. I don't think the judge spent much time on that, although there were some comments made in passing on that. We've got a letter on Friday last week from the Constitutional Court asking us to file papers by the 9th of June. Government's been given to the 12th of June to hear whether the case will be heard or not. But we take this as a very good sign. I think if the court didn't feel there was a prospect of elements of constitutionality being raised, that they would have simply dismissed the direct access. They have asked us to now make the case, and we're pretty confident that we will be able to make a solid case on constitutional grounds around why this act needs to be challenged.
Yeah,